it's really in the child's best interest, barring any type of emergency or you know, other circumstances. It's just, it's good practice to have that in place. And the process, I'd like to say, like, the reason why I like to start at age 17 is because it could take about a year. And this was pre-COVID. Since COVID, it's been taking much longer than a year to work its way through the court system. It takes a while for the doctors, because there's a lot of follow-up with the doctors or the licensed psychologist and the doctor to get their affidavit and their report just right, and then submitted to the court. The court also has to do a background check of the individuals applying for guardianship, any adults living in their home, as well as the standby guardians, which I'll mention in a minute. And with this background report goes to Albany, and they look at the last 28 years to see if there's been any reports filed. And so oftentimes clients have to come up with their 28 years of address history, and they may not remember exactly, so they have to go through and figure that out. But that report takes a while getting back from Albany. And once we file everything with the court, oftentimes the courts, and I mentioned before, it's done in the county where you reside, and it's done through the surrogate's court. So the surrogate's court in the county where the child resides. And not the family court, because some guardianships of minor children can happen in family court, but for purposes, or custody issues or whatever, but for purposes of individuals attaining 18 years of age, when we're dealing with intellectual or developmental disabilities, this actually happens in the surrogate's court. And so the surrogate's court are oftentimes backlogged, and it's a waiting game. And so we file the paperwork, even if, you know, all our paperwork's in order and we don't have to do any modifications or amendments, but sometimes we do. We file it with the court, and then it's a matter of, it sits on a pile, unfortunately, but the court is, you know, understaffed and overworked. And again, this was pre-COVID. And so it takes a while for our case, or for our client's case, to be up next. And when they're up next, which it could be anywhere from, you know, 4 weeks to like 12 weeks, 16 weeks, depending on the court. And, you know, once they're up, the court will review the paperwork, everything that was submitted. And then they may want some additional supplements. They may want some amendments. If everything's in order, they'll mark it submitted, and they're going to issue what's called a citation. And the citation is a date of a hearing, a potential hearing, because not all courts have hearings. But this is the date that the judge is going to hear the application for the appointment of a guardian to be made. And any objections can be made at that hearing date. And the citation, usually, the hearing date usually takes place about 30 or 60 days after, because oftentimes we have to do service. We have to serve the citation on interested parties. Some judges will appoint what's called a guardian ad litem, which is an attorney to represent the interests of the individual who we're asking to have a guardian, somebody independent. Most of the time, if we're not dealing with financial assets, the courts will appoint mental hygiene legal services, or sometimes referred to as MHLS, to be, you know, to do that investigation on behalf of the court. And some judges do, they don't appoint MHLS, and they don't appoint a guardian ad litem, and they do the investigation on their own. I have a guardianship next week in front of Surrogate Mella in New York County Surrogates Court, and her practice, if there's no assets, is to not appoint a guardian ad litem or mental hygiene legal services, and her staff, her attorneys, do all the investigation. In Westchester, where we practice frequently, the court will routinely appoint MHLS, mental hygiene legal services, to again do the investigation, unless if there's assets. If the child has assets in their name, then oftentimes the court will appoint that guardian ad litem. And then once we have the date, the hearing date, every court handles it differently. In Westchester, frequently it's a fairly straightforward proceeding, and the family and the individual who we're asking for guardianship does not need to appear because Mental Hygiene Legal Services has already done their report and their investigation. Whereas, you know, in other counties, the Bronx, in Nassau, and in New York, Kings County, pretty much all the other counties except for Westchester, now that I think about it, will actually have a hearing. And it's usually an informal hearing. We don't have to, you know, put somebody in the stand and cross-examine them or you know, take formal testimony. Oftentimes we're sitting across a table or at a table with the judge and the judge's staff. And there is a court reporter, and the judge will ask questions, and not mainly of me, but actually the petitioners, oftentimes mom and dad, and the child. And I always tell my parents not to worry if your child's not going to, you know, talk at all, because oftentimes the children don't even talk or verbalize either their wishes, or they're not able to. And sometimes they have to get up and walk around, and that's okay. You know, it's usually there's nobody else in the courtroom. And it's okay. You know, they understand. Otherwise, you wouldn't be asking for guardianship. Since COVID, I've had all my guardianship hearings by virtual, by either Skype or Team. I haven't had any in-person guardianship hearings yet. So the process has been a little bit different. And families have to have the, you know, ability to be able to go onto a Skype meeting, and they use Business for Skype or Teams, and have the virtual hearing that way. Also, I will say, since COVID, I have filed cases back in March and February that I'm just getting hearings for now. One we filed in February, and now I have the hearing finally, and this was New York County. I have it next week. So we waited 7 months since we filed the case. So it's unfortunate. It's very stressful for families. You know, you know, it is what it is. It's fortunately, in none of these situations have we dealt with any emergencies where there was a situation where the parent, or really mainly the parent, could not advocate or make medical decisions for their child if there was an emergency. If there was, then we actually, since COVID happened, the court was making exceptions and having emergency hearings if there was ever an emergency. But I didn't have any families that fortunately had that situation. When we apply for guardianship, we asked for and oftentimes it's the parents, but it may be other family members or close friends. But we ask for guardianship of the person and sometimes property. And there's a difference, and each court handles it a bit differently, although for the most part, a lot of the courts are aligned, except for Westchester is a little bit of an outlier, which I'll explain. Guardianship of the person is what almost everybody needs and what everybody wants. And that's be able to continue basically your parental, what you've been doing as a parent, and continue what you're doing as your everyday as a parent, but legally when your child becomes emancipated at age 18 and legally becomes emancipated at age 18, and they're officially appointed as the guardian. Sorry, I apologize. Somebody came in and I forgot to put a do not disturb on my door. And that's to be able to make medical decisions, where the child resides, to unfortunately sometimes make end of life decisions, but basically do everything related to the person. Then we also have guardianship of the property. Most courts will not grant guardianship of the property if there are no assets, if the child himself or herself has no assets. And what I mean by that is that if the child has a bank account or a UTMA account and there's significant amount of money in that, once the child turns 18, well, in New York, we have until age 21 where we have a Uniform Gifts or Transfers to Minors Act, but they could lose access to that. And if we're dealing with a capacity issue, nobody really has the capacity to be able to access those funds. and that's why I typically recommend, if I counsel clients early enough, when their children are early enough, I usually recommend that they not have any custodial accounts in their name. Because once there are assets and we have to ask for guardian of the property, those assets now are going to be in joint control with the court. And whenever you want to spend money, you're going to have to get permission of the court. You're going to have to file annual accountings. You will have to, sometimes you'll get bonded so you have more flexibility and not having to ask permission of the court when you want to spend money. But the idea is that you want to have, you know, it's just a very difficult, and it's very stressful for parents because they got to do everything on their own before. Now, why do they have the court involved? Why does the court have to be involved to make these decisions, or to that they have to get approval or oversight of? You do not need guardian of the property if your child is going to have work earnings or Social Security, an SSI, Social Security disability. In terms of any type of benefits they may receive through the Social Security Administration, which is mainly Supplemental Security Income, SSI, or Social Security Disability, SSD or SSDI, you would become representative payee through the through the Social Security Administration. Guardianship of the property has nothing to do with that, and the court doesn't want anything to do with that. So they're bifurcated, okay? So you don't have to be guardian of the property in order to be representative payee. You don't have to be representative payee to be guardian of the property. They have nothing to do with each other. Similarly, if you are a trustee of a trust, or your child has assets in a trust where there is a trustee designated, you don't need to be guardian of the property in order to access or attend to those assets in the trust, because the trustee is responsible for those assets. Now, we have encountered problems recently, and let me just say that in Westchester, Westchester is unlike other counties where we actually can apply for guardian of the property. And we routinely do, even if there's no assets, just so that we have it there if it's ever needed in the future. Parents are required to file annual accountings. If they're guardian of the property in any county, you have to file an annual accounting. And if there are no assets, which this would only happen in Westchester, the accounting would just be all zeros. It's basically a form that you handwrite in, and it's all zeros. You submit it to the court each year. Excuse me. On that annual accounting, you don't account for Social Security money or any work earnings. It's only the child's own assets. Now, where we've had some problems recently is ABLE accounts. And which is new, which again, we've had another seminar on this or presentation on ABLE accounts, or we have some articles on our website. But basically, under New York State, our ABLE program, if you enroll in New York for an ABLE account, which basically is a tax-free account where you could shelter some money up to $15,000 a year for a child with a disability, if the disability onset was before the age of 26. And it's a way of providing some autonomy to your child. The assets in an ABLE account are exempt, and then it gives your child the ability to be able to access these accounts and use them for disability-related expenses. We have found that an issue in that our counties where we have only guardian of the person, that New York ABLE program has not allowed the parents, if they're, or whoever's the guardian of the person, to not enroll in an ABLE account because they don't have property guardianship. So it's a bit difficult, and I tell all my clients to go to a different state because there's other states that will accept them, and I often refer them to Ohio where we don't have this nuance in this issue, because it would be, you know, quite costly for the clients to have, for us to have to go back to the court, do a modification proceeding so that they have property guardianship for us to be able to join an ABLE account in New York. I mentioned before, you know, because oftentimes we'll get families that will come to us that have a child, oftentimes they're an adult child now, that suffer from some form of mental illness. And unfortunately, most of the time, an Article 17A guardianship is not appropriate. Also, oftentimes, the types of guardianships we have in New York are not appropriate for various types of mental illness. We have, again, for 17A, we have to have that underlying developmental disability or intellectual disability diagnosis. When you apply for guardianship, you will choose what they refer to, the court and the statute refers to as a standby guardian. And that's basically an alternate guardian. So that if there comes a time when you or your spouse or whoever you have, whoever's the primary guardian, can no longer act, you have a successor in place. Once it comes to the point of you not being able to act, then the standby guardian has 180 days to qualify. So they'll be able to act from the moment of when you're no longer able to act as guardian. They could act for a period of 180 days without being confirmed by the court, but they are required to submit a petition, another petition to the court to confirm their appointment as guardian, and they will get the letters of guardianship, which is their official guardianship form. More than one person could apply for guardianship, so we could have co-guardians. That's often the case that mom and dad will apply. There are situations where we have divorced parents and the parents have different ideas and they want to designate different standby guardians, and sometimes we have different lawyers involved. You know, I may represent the dad and somebody else may represent the mom, and the courts, for the most part, are not interested in rehashing any custody disputes in this particular court at all. And so they will almost always settle this, and they'll work very hard with the attorneys, assuming that usually in these situations, the parties are represented by attorneys, to try to settle this because they don't want to go to a formal trial on this, and they'll, you know, some settlement will be reached. It's unlike, you know, what happens in matrimonial and family court proceedings. The court pretty much has a zero tolerance with you know, getting involved in these disputes, with some exceptions. Guardianship is in place for the duration of the child's lifetime, unless if it's revoked by court order. And this is important because this is when I get to the advanced directives in a couple minutes. You know, I'm going to talk about this, but the guardianship is for the child's lifetime, unless if it's revoked by court order. Now, I recently had a situation where we applied for guardian for a child who's now an adult. When he was 17 years old, he had his diagnosis was autism, and in Westchester we applied for guardian the person and property. And actually, he actually had some assets in his name. And fast forward 10 years later, the parents said, you know, we want to, he wants to, and we want to revoke the guardian of the property. You know, he still wants us to be guardians of his person because he has significant anxiety and stress, and he can't communicate effectively with his healthcare providers and his medical providers. And so we still need that guardian of the person, but he's matured enough, and you know, the way that his mind worked is he was capable of managing his financial assets, and we were able to prove that. And we were successful in the court modifying the guardianship to actually continue guardian of the person, but revoke the letters of the property guardian, which there, you know, wasn't too much precedent in New York State in terms of case law when I had this proceeding, and it was very successful. Parents were very happy. But so my point is yes, this guardianship is in place for the child's lifetime, but it does, you know, sometimes we have to go back and we have to seek a modification. The other unfortunate thing about the way that the 17A statute is designed is that it's not tailored. It's an all or nothing. It's what we refer to as a plenary guardianship. and we cannot tailor it to the child's individual and unique needs, which is often the case for individuals with developmental disabilities, because they have different abilities and capabilities, but oftentimes they need significant support in certain aspects of their life, and we're not able to tailor the guardianship. Over the last 5 years, there have been efforts made to New York State Legislature to modify our 17A guardianship, but nothing has passed. It's definitely ripe to be reviewed and to be mainstreamed into current society, and just freshened up, and basically for the protection of these individuals, but also allowing them as much autonomy as possible. And what we refer to as what's the least restrictive alternative. So I'm going to move on to just advanced directives. And on that note of the need to modify our 17A statute and to really modernize it and bring it up to present day, where we're dealing with, as I mentioned, many individuals that have various abilities and capabilities. There's the idea, and not just in New York, but throughout the world, of this person-centered approach to supported decision-making. In that, what supports can we put in place for this child that has needs, but we don't necessarily want to take any rights away from them or deprive them of rights that they rightfully are deserving of. And so, oftentimes we'll look at advanced directives, and I'll meet with the child when they're 17. I'll look at some of the psychological and some of the testing that was done through the schools, and we'll make a determination. Okay, what's the least restrictive and still most protection for the child here, and are they capable of signing advanced directives, meaning power of attorney, which is financial decision making, designating somebody to be your agent to be able to make all financial decisions on your behalf, and healthcare decision making through a healthcare proxy. Do they have the level of capacity? And there's different capacity requirements for each of those documents, but do they have the basic understanding of what these documents are, who they want to designate, and the consequences of signing those documents. And we evaluate the risk and the benefit, and because it's certainly a gray area, and we work with the family, we see what the goals of the family are, what the child wants, because is a power of attorney and a healthcare proxy more appropriate? I will also say on this note, in this person-centered supported decision-making standard that's that we don't have in the law yet, but we're moving towards, is we have several surrogates in this New York State, lower New York State area, Westchester, Kings County. Surrogate Lopez Torres has written significant court decisions on the least restrictive standard, even though it's not in our statute. And so the surrogates now are really making sure that a 17A guardianship is appropriate and the least restrictive alternative for the child. And are there other alternatives, such as healthcare directives and financial directives, that are more appropriate for the child? I'd say the downside and the stress of the parents of these advanced directives is that, unlike a guardianship where it's in place until the child dies or it's revoked or modified by the court, is that with these type of legal documents is that your child can actually revoke them, and that's a fear. If they're ever unduly influenced and they, revoke their power of attorney, and then they go to somebody, and they designate somebody else, that's a big stress of families. Now I would think, at one point I had a proceeding a few years ago where we tried a power of attorney and healthcare proxy, and the son was subject to significant undue influence. And we were able to demonstrate that to the court, why we tried a power of attorney in healthcare proxy and it was not appropriate, and here's why, and we were successful in getting guardianship. It's hard to do once somebody already signs a power of attorney in healthcare proxy, but we had significant evidence to show why it was justifiable, you know, to grant that guardianship. And also, so in terms of the advanced directives, I always like to have my individuals who are 18. And these documents, unlike a guardianship could go in place before somebody turns 18. So it could be put in place at 17, 16. With advanced directives, the individual can't sign them until they're 18. And I have had families that have, you know, on the child's 18th birthday, I've met with them in our office to sign power of attorney, healthcare proxy, and a HIPAA release. I don't always do a living will for a young adult. Living will is what your wishes are regarding your care at the end of your life. And oftentimes young adults don't know that. Whether they have any type of disabilities or not, I find that they think they're invincible and they're never going to die, so they've never even thought about a living will. And in New York, there's separate documents, and what's most important in New York State is the healthcare proxy, which is designating somebody to make medical decisions for you or assist you with your medical decisions. So let me just check my notes here to see if I have any other points that I wanted to make. And then I'm going to open it up to questions. One thing is that if you move to another state, New York's Article 17A is limited to New York State, and it's not meant to carry to other states. And so oftentimes, if the child permanently moves to another state, we'll have to do an application to transfer the guardianship to that new state so that the powers are appropriate and subject to the laws of that state. If it's a temporary basis, sometimes for school or something, we'll keep the guardianship in New York. Similarly, with advanced directives, power of attorney, healthcare proxy, while as long as they're valid in the state that they were executed and created in, they are supposed to be valid in the state that you move to, but it doesn't hurt to also just sign, you know, if the person moves to North Carolina, sign a North Carolina power of attorney and healthcare proxy. You don't have to revoke your New York ones, but you know, you want to make sure that they don't conflict with different agents, different individuals appointed, but it's okay to have more than one state. Okay, so there's a question is, what if there is sole custody? Usually custody issues only deal with the child until they're 18. So under the laws of a guardianship, the parent who is not the sole custodial parent has to consent. Now, there may be agreed that they'll waive their right to be the guardian, but they have a right to be guardian even if they're not, don't have sole custody while the child's a minor, which causes a lot of stress and tense situations. And you know, a couple times throughout the years, I've had to demonstrate to the court why there was sole guardianship and why it's not appropriate to have the non-custodial parent as a guardian, and we have to usually demonstrate by evidence. Other questions? Are there other questions at all? Just making sure. Okay, can I explain an ABLE account again? Yes, I will briefly, but then we have, if you go to our website, littmankrooks.com, we have some articles. We may have a webinar on there that we did a year or two ago, because nothing's changed in the last 2 years. So if it's a couple years old, there's been no significant changes. But the ABLE account is the Achieving Better Life Experience Act. And the idea is to be able to shelter money in this ABLE account for your child who, and usually they're recommended, there's various reasons why we recommend ABLE accounts. They're not appropriate for everybody. They're not meant to take the place of a supplemental or special needs trust. But the idea is that they you could set aside up to $15,000 into this account, and the money is exempt. It doesn't count in terms of any eligibility for government entitlements such as SSI, Medicaid, and the funds can be withdrawn by the beneficiary himself or the legal guardian or a power of attorney to pay for disability-related expenses. Disability-related expenses is extremely broadly, is broadly defined in that it could be housing expenses, it could be food, it could be medical expenses, it could be education expenses. So it's pretty, like I said, it's broadly defined, but it's a way, especially for capable beneficiaries, where they are limited in what they could have in terms of assets and income. If they need to rely on any type of means-tested government benefits, it allows them a little cushion to be able to have another source of funds. Okay, let me just scroll back up here for a minute, because a couple of them came in. Is the beneficiary of all my assets as well as my pension? I changed. Okay, I'm a single parent and my son is the beneficiary for all my assets as well as my pension. Should I change that and appoint someone else in the event something happens to me? First of all, if your child is a minor, they should go into, under your will, you should have a trust, or just have some type of trust established for the child, so that a minor who is not disabled, I should say, that has no disability, but have some type of protective trust. Otherwise, if we're dealing with a minor child and they inherit, all the assets are going to be joint control with the court. Also, if the other parent could apply to be the guardian of the property and they could have access to it. Whereas if you do a trust for your child, you get to choose the trustee. Now, your will can set forth the guardian of the property, but again, even in sole custody situations, the other parent has priority to be guardian, if we're dealing with a minor situation or an adult situation. If your child has disabilities, then you would want to consider potentially a supplemental or special needs trust, a third party, and it doesn't matter if the word supplemental or special is used, but a third party supplemental needs trust, which is funded with assets never belonging to your child. And this purpose of this trust is to be able to inherit assets that you would otherwise leave directly to your child. And it's exempt. It's not counted in case they ever need to rely on any benefits. And again, that is something where we use a trustee manages that. What if a child turns 18 before the guardianship proceedings have been completed? Also, will anything be taken into account due to the court delays for COVID? As I mentioned before, and I don't know when you came onto the call, but there's many guardianships that are not in place by 18. Oftentimes, I'll meet with families and their child's turning 18 next week or next month, and so the guardianship's really likely not going to be in place until their child's 19. Other times I've had, as I mentioned, all ages that I've had where we've applied for guardianship. And with COVID, if there was an emergency situation, then we could fast track it. But barring an emergency where it's actually a life or death situation, the court, we're just going to go, because everybody else is just as a priority as your case, unfortunately. But we'll just, you know, they're going to take them as they come in. And I will say that New York also has what's called a Healthcare Decisions Act, where if there's any hospitalizations, if your child happens to be in a hospital, there's no healthcare proxy in place, and there's no guardianship in place, and there's a hierarchy of the individuals who could act. And if your child is not married and does not have children, then you're the hierarchy. You get first say in terms of making medical decisions in a hospital. Doesn't help you outside of a hospital, though. I have a family member who has a serious mental health condition that began before he was age 22. Very good question. Would this form of guardianship apply? Unless if there's some of my situations where we have a developmental disability such as like autism and there's an underlying diagnosis, If it's solely mental illness, we cannot go through this type of guardianship proceeding. We'd be looking at sometimes in Article 81, but the judges in Article 81s, which is a very complicated guardianship. It's a lot more complicated than 17As. Like sometimes we're successful in getting guardians there. It's a different standard. Sometimes there's other mental health proceedings that can take place if it's requiring confinement or medical, or not medical decision making, but requiring medicine. There's this thing called Kendra's Law. So it's very difficult. Actually, it's impossible. If it's only mental illness, we can't do a 17A guardianship. I will also say one thing that I wanted to mention before, and I know there's a couple more questions, but we're in an election year. And this is the time of year where I get phone calls from families saying, my child, I'm guardian of my child and they want to vote. Can they vote? And I say, yes. I mean, assuming that they, understand the general concept of the election, and, that they could, they could. I mean, there's certainly, there's areas in individuals' capacity, even if they have a guardian, where they clearly can't make a decision in terms of voting. Or sometimes they can on the higher functioning individuals, because under our New York State Constitution, it just says that those declared incapacitated cannot vote. Under our 17A guardianship law, and I've been through it back and forth, there's nowhere in our law that somebody is declared incapacitated under the 17A statute. Now, you could go to a different attorney and they may have a different opinion. This is my opinion. That an individual, if they're capable of, having that basic understanding of the election and who they want to vote for, they could vote. Now, again, other practitioners may feel differently, but I read like the actual law, and I don't see anywhere in our 17A statute where somebody's declared incapacitated, which means they can't vote. I'm sorry, it's not incapacitated, it's incompetent. It's the word's incompetent in our New York State Constitution. For individuals who can't vote, and that's not in our 17A statute. Okay. So to clarify on the question in terms of how long it takes if the child turns 18, and the petition is pending at the surrogate's court but not completed yet, does a healthcare proxy power of attorney or advance directive, should it be signed? Probably not. I had this case one time. And the court found, discovered that there was a power of attorney and healthcare proxy signed by the child because they turned 18, and the court denied the guardianship. Mom and dad couldn't be guardian because the court said, well, explain how a guardianship's more protective than the power of attorney and healthcare proxy, and where, our arguments were X, Y, and Z, and including that, potential of undue influence, that it could be revoked. And the court said, sorry, they signed this power of attorney and healthcare proxy, unless if you could show that there's been an actual undue influence, or that they were revoked, then, we're denying the guardianship. So I wouldn't sign a power of attorney. I wouldn't sign advance directives if you have a guardianship pending. Do expenses with an ABLE account need to be reported annually to the court under the property guardianship? I haven't seen it, no, because there's a separate accounting requirement for the ABLE accounts, even though I don't know if it's being strictly enforced. But the courts will not, I haven't seen anywhere where we've had to account for ABLE account expenditures in a 17A guardianship accounting. You mentioned a third-party supplemental needs trust. Does a guardianship affect that at all? No, one doesn't necessarily have anything to do with the other, because sometimes, well, and sometimes, so supplemental needs trusts have to do with assets that never belong to the child. If we're talking about a third-party supplemental needs trust, and that's usually set up by the parents, and there's a trustee designated, and now the trustee of that trust and the guardian can be two different individuals, or sometimes the trustee can be a corporate trustee, such as a corporate financial institution, and it's important for them to work together because the trustee is going to rely on the guardian to know what the needs are of the beneficiary, and the guardian is going to rely on the trustee to help support the beneficiary. But I would say that's the impact and the overlap of those roles.
Could they possibly be the same person?
Yes, they can, and oftentimes they are. Oftentimes they are the same person. Sometimes they're siblings. You know, when we fast forward later into life, mom and dad are much older or they're deceased, and we have two siblings, you know, and they could fill both roles as guardian and trustee. Can a school triennial psych report serve as purpose of the psych documentation? Yes, we do. So yes, we do the triennial reports as part of the documentation that we submit to the court, but you also must have the 2 doctors' affirmations, or 1 licensed psychologist affidavit and 1 doctor's affirmation. So that is required, but we do submit those reports as evidence. Would I reiterate quickly why it's better to take guardianship just of a person rather than person of the property? Okay, so I'm actually a fan of having guardian of the property, having both guardian of the person and property. I'm a proponent of that. It's the courts that don't allow it, okay? If there's no assets, then the courts will not grant guardian of the property except for Westchester. And Westchester now, just in the last 2 weeks, is starting to maybe backtrack because they're seeing that they're really the only county that's out there. So I'm a fan of it. I feel like the courts don't want to grant it because then it's just more cumbersome on them, because then they're going to have to follow up with the guardians to file their annual accountings and their annual reports. Whereas if you're guardian of the person, there is no accounting or reporting requirement whatsoever to the court. Once you become guardian of the person, there's no more need to go back to the court, which there's pros and cons associated with that if you're guardian of the property. Is Asperger's considered for Article 17A? Yes. And so, yes, Asperger's syndrome is, or you know, this various spectrum disorders. But again, you need to show substantial limitations, or we will, as part of the application of why, because oftentimes with Asperger's, we have to really demonstrate to the court a lack of capacity for the need of a guardian and why that individual cannot sign a power of attorney and healthcare proxy. Courts generally will look for, on the testing, the full scale IQ in the low 70s, mid to low 70s as a baseline. If it's above that, then we really have to demonstrate to the court why we need a guardian. And oftentimes with Asperger's type diagnoses, the testing comes in much higher than that. The property guardianship is done as, it's just a box that you check, and it's a couple extra information you complete on the petition for guardianship. It's all the same petition. When you apply for guardian the person, you would just, at the top right-hand corner, you check the box, guardian the person or guardian the person and property. So if you already started preparing guardian the person and property and it's not submitted, how easy? You just have to modify your petition. You have to go back and modify all the paperwork, because it says usually that, so you just have to modify the paperwork. My son is in his 50s, although his disability began well before the age of 21. I do not have reports for all those years. So we have to prove that, the idea is that you have to prove the disability, the onset of the disability before the age of 22. If I could just pull up quickly in my statute how it says, but I know that the onset of the disability has to happen before the age of 22. But you have to demonstrate that the individual was disabled. So you have to, I don't know what records you have, but you're gonna have to demonstrate that. Okay. If you are someone's guardian and they commit a crime, can you be held responsible if they run away, refuse food, something like this? I have not seen it. So my short answer is no. However, if it's demonstrated that you were neglectful in your responsibilities as guardian, or you were abusive, and I know you're not asking this question specifically for you, but just generally, but if the individual was neglectful, there could be some association there. I'm not a criminal lawyer, and I have not come across any situations of my clients where this situation occurred, where the parents were held liable or the guardian was held liable. Now, I've certainly had situations where individuals who are under a guardianship got themselves into trouble, whether they were smoking pot or, the one time I had, they were writing fraudulent checks. And actually I had another one where they set a neighbor's garbage can on fire. And none of those situations were the guardians, in all those cases, I think it was mom and dad, were they held liable, personally responsible at all. Not saying it could be ruled out, but I haven't seen it. Is it possible to have only guardianship of the property, but not personal guardianship? That's the first part of the question. Yes, but you don't really see it that often, because usually it's that medical decision-making that is really necessary. But it is, you just have to demonstrate to the court why the guardian of the property is necessary and guardian of the person is not. The second part of that question is, what is the difference between guardianship of the property and special needs trust? Good question. Maybe I should have a topic on this one time, because we could spend a half an hour talking about this. But basically, short answer is guardianship of the property deals with assets in the individual's name, only in their own name. It's not in a trust, but it's in their name, and they don't have the capacity to manage those assets. With regard to a special needs trust, that is a separate entity. It's almost like a separate individual or entity, and it has oftentimes its own taxpayer ID number. So you look at that, like the guardianship is the individual, and so that's why then the special needs trust is another individual. It's somebody separate, and that's why, and that we have a trustee of. So that's why sometimes, there's two different roles there, and oftentimes there are two different roles. If the individual does not personally own the assets, but has assets in trust for him or her, the trustee manages those. A guardian of the property only deals with the individual's own assets, and the trustee deals with the trust assets. And they're separate, completely separate. Okay. Hold on, let me just see where we are. We're getting a lot of questions here. As a guardian, does guardian have any personal financial responsibilities for the individual? No. So a guardian under 17A statute has no personal responsibility for the individual. Oftentimes it's mom and dad, and they will help out, but there is nothing under the law that makes them financial responsible at all. The reason why we as the parent petitioners are asking for the property guardians because we do not want anyone to take advantage of our son. For instance, make him sign or purchase something. So that's the undue influence. So if your son does not have assets, then if it's not in Westchester County, it's going to be very hard to get guardian of the property. And also you will have to demonstrate to the court why guardian of the person is not also necessary, because there could be undue influence there as well. I have to wrap up in a minute. Let me just finish this one sentence, this last one question. Can you talk more about what a healthcare proxy is used for? Healthcare proxy is used for healthcare decision making. And it's again, that's a type of document. You could actually go to our website, littmankrooks.com. On the front page, we have a healthcare proxy form. Now, I don't recommend your child signing that for them if you're applying for guardianship for them, but it's the New York State document where you designate an individual to make all healthcare decisions for you if you become incapacitated. And including end-of-life decision. It could be everything from, a parent having cancer and talking to or dementia and talking to their providers, their medical providers about treatment or treatment decisions, all the way to end-of-life decisions. All right, I guess there's still a couple people on here. Let me see, I know there's a couple more questions. If the parent is the trustee of it, to clarify, if the parent is the trustee of the special needs trust, then does that mean that the child is not the property owner of the special needs trust? That's a very good question, because sometimes, so quickly, no. If there's a special needs trust, the child does not own those assets. And if we're looking, there's different types of special needs trusts. There's third-party special needs trusts and first-party or self-settled special needs trusts. There's also pooled trusts, which I'm not going to talk about because that'll just be confusing. But with a third-party supplemental needs trust, those are assets that never belong to a child. Mom and dad did their estate plan, they set aside money for their child, and that's what goes into the third-party trust. That's not their money, it's exempt. With the first-party special needs trust, that is assets where the child got money in their own name, and we want to, and one is that they may not have the capacity, and we don't want to use a guardian of the property to be able to manage those assets. And more times than not is that they need to rely on some type of government entitlement, such as Medicaid or SSI. And we want to exempt those assets that the child received, either through an inheritance or through a personal injury settlement or some type of other windfall. And we want to protect them, and we move them into what's called a first-party special needs trust. Those assets are technically the child's assets, but they're in a separate entity again, and they're exempt. They're not counted as the child's assets. Now, for IRS purposes, they may count as the child's assets, and we may want it from a taxation standpoint, but for purposes of SSI and Medicaid, they're exempt and they're not considered the child's assets. Okay, I feel like Kian and Maria, my next Lunch and Learn should be on special needs trusts if we haven't done one recently. So everybody keep an eye out for the next series of our Lunch and Learns. Maybe we'll do one on special needs trusts. If you have a guardianship over someone, can they still write checks? Excuse me. No, yeah. Can the child with the disability write checks, or who has the guardianship? Usually not, because their name's not on the account. Sometimes with representative payees, they can, if they're on the account on the Social Security funds or on work earnings, they can, because again, those are typically outside of the guardianship. Okay, so I'm going to end here, and we will do another Lunch and Learn at some point on special needs trusts, and I'll talk about first party, third party, and maybe even pool trusts. Thank you all for attending. If you joined halfway through this, I think that this will be put up on our website at some point, or YouTube, on our YouTube channel. Okay, thank you. Take care, everybody. Be well.